afternoon, and thank you for joining us for the sixth webinar of our Business Recovery Series. The series is intended to provide businesses with training, information, and resources necessary for business success, recovery, and preparation for unplanned events. And the series is brought to you by the City and County of San Francisco Contractor Development Program and the Alameda County Contractor Technical Assistance Program. Both programs are administered by Merriwether and Williams Insurance Services. My name is Judy Singharath, Program Marketing Manager at Merriwether and Williams Insurance Services. Today's webinar in this series focuses on helping you understand construction contract terms. Now, with that, I want to pass the mic on to Carol Henry, who is our Program Manager for Merriwether and Williams Insurance Services. Welcome, Carol.
Hi, good afternoon, everyone. Again, thank you for joining us today. I'm Carol Henry, and I'd like to welcome you on behalf of the Alameda County Contractor Technical Assistance Program and the City and County of San Francisco Contractor Development Programs. Again, both programs are administered by Merriwether and Williams Insurance Services. The programs are designed to assist small, local, minority, and women-owned contractors to participate and navigate in the work in the public works arena. We work with small and emerging contractors to ascertain their business needs and to ensure that they have sufficient resources to enter into public contracts. The goal is to assist small and emerging contractors in their growth and to remediate some of the barriers that might prevent them from being successful. We offer various technical assistance services, as well as assistance with bonding for contractors seeking to bid on public works. We do this by identifying the strategies to help grow and strengthen your business. The first step would be to set up an appointment for one of our one-on-one evaluations to identify which technical assistance services your business may require. The goal of the evaluation is to create a strategic development plan that fits your business needs and utilizes the services we offer. Our contact information will be displayed at the end of this webinar. Please contact us via email to set up an appointment to see how we can work together. As a reminder, please complete the webinar evaluation, as your feedback is important and helps us improve and provide seminars that are most helpful to your business. And with that, I turn it over to Jennifer Elmore, Program Manager for the Contractor Development Program and the presenter of today's webinar.
Thank you, Carol. Thank you very much. I hope you I apologize, but in order for you to hear me and to be less technical issues, I'm going to have to turn off my video during the presentation to make sure that you can hear me. So welcome today, and next slide, please. Welcome. The information provided in this seminar does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only and given as a result of Merriwether and Williams' experience working with small and emerging contractors. The webinar is not to be construed as a substitute for review by legal counsel and other professional advisors. It is our recommendation that contractors should have an attorney review all their contracts. The purpose of this webinar is to give you some insight into your contracts and how contracts affect your relationship either with an owner and or prime contractor. I want to thank everyone today for attending. We'll start with tips before you bid. Next, we will review contract language showing sample contract language. Lastly, we will review a partial checklist of all the topics covered today and compiled to help you review your contract. At the end of each contract section, we will pause and ask if there are any questions. Please submit them, the questions via the Q&A section, and we will do our best to answer. The premises of this seminar is to assist you in understanding your contracts before signing, especially if your company cannot currently engage or retain an attorney. Also, we want to remind you that sometimes it is possible to negotiate not just your bid, but potentially some of the terms and conditions of the contract. And with that, next slide, please. Before bidding or entering into a contract, do your diligence and understand the reputation of the owner and or prime contractor. As a first step, review the reputation of an owner or prime contractor and their relationship with other subcontractors or other prime contractors. To find out more about owners or prime contractors, you can speak with other small and emerging contractors. You can Google the prime's name, contractor's name, and include the words litigation or lawsuit. One thing to pay attention to is also to see that the prime contractor has worked in your geographic area, or are they new to the market? Also, just as subcontractors usually must pre-qualify to work with prime contractors, vetting a prime contractor owner in advance of entering into a relationship is important. And some of the items you can learn in advance are payment terms. What is the pay cycle? And do they follow what their contract says? Ask for a blank subcontract agreement in advance so you can review the terms and conditions in the subcontract agreement. If bidding to the city and county of San Francisco or Alameda County, you can search for contractual boilerplate language online to know the terms and conditions before you think about bidding. Additionally, does the prime contractor have performance and payment bonds? And find out how to file a claim with the prime surety company. If working directly with the government entities, find out the stop notice process and where you file that in advance. Contractors should review plans and site conditions. Reviewing site conditions in advance of bidding for potential variations or conditions that may create necessary changes in your bid proposal. As a subcontractor, make sure that you bid your scope of work. Contractors bidding the same scope of work will have divergent prices. For small and emerging contractors, there is a larger cost in running a business. And when working with the larger primes or larger specialty contractors, it becomes a necessity that you bid your scope of work to reflect your actual costs. Find out in advance if performance and payment bonds are required by the owner or the prime. What is the price of the bonding? You can ask in advance of the owner or the prime if the bonding is to be included in your bid price, or can you include it as a pass-through cost? Those are some of the things you can do in advance of the bidding phase. Next slide, please. Before you sign the contract, review the contract. Now, these are simple things that you can do just for yourself. When you review your contract, make sure that the price and scope in the contract matches your bid proposal scope of work that you negotiated or submitted to the prime. Confirm that that scope in the agreement matches the scope of work in your bid proposal. Ensure that the agreement, subcontract agreement, accurately states and includes the exclusions from your price proposal. Ensure that the negotiated items are included in the contract before signing the contract. We recently worked with a subcontractor that had negotiated weekly payments from the contractor, but the subcontractor and the exhibits to the subcontract only had standard monthly payment terms. The subcontractor was able to have the prime make the change before signing the contract, which relieved quite a burden on him. If subcontractor, review prime owner terms and conditions. As we will discuss later in this presentation, subcontract agreements often bind subcontractors to the same terms and conditions that regulate the owner and prime contractor contracts. I'm going to pause to see if there's any questions before we move on to the next slide.
There was a question regarding if the recording will be available to attendees, and the answer is yes.
Oh, nothing for me to answer. Okay.
No.
Okay.
Continue.
Thank you. Next slide, please. So this is the first part where we get into the terms that are actually in the contract that aren't part of what you've bid. So the first one that we're going to kind of review are two items that are very similar, and they are flow down provisions or incorporation by reference clauses. And as it says here, a flow down clause is a contract provision by which the parties incorporate the terms of the general contract between the owner and the general contractor and the subcontract. And incorporation by reference is where they name the documents that are included in the subcontract agreement and say by reference. Next slide, please. So this is what they look like. And it differs contract to contract. So you'll be able to find it, but it'll say something about flow down, or it'll say entirety of contract, or terms and conditions. The flow down incorporation by reference clauses add to the subcontract terms the plans, specifications, conditions of the contract, drawings, and addenda issued prior to the execution of the agreement between the owner and a prime contractor, and all other documents unique to this project. These provisions also allow the project's owner to impose obligations and restrictions on a subcontractor despite there being no contractual relationship between them. This means a subcontractor is required to know the terms and conditions of the owner prime contract. Therefore, when signing a subcontract without reviewing the master contract terms and conditions, subcontractors do not always know fully to what they are agreeing. Therefore, subcontractors should ask for a copy of the general contractor's agreement. The prime contractor may redact the agreement to hide confidential information, but the prime contractor should be able to provide a copy of the owner's terms and condition to the subcontractor for review. So what are some of the most pertinent items that are passed down? And here are some examples that we'll review in this presentation. The schedule, the liquidated damages, the warranty period, insurance requirements, indemnification, payment terms, and claim requirements. Are there any questions?
No questions at this time. Thank you, Jennifer.
Okay, I won't ask again. You'll just tell me. Next slide, please. So, schedule or time is of the essence clause. These what the time of the essence clause does is the schedule becomes a material term of the contract. Another thing to make sure of in the contract is the contract based on calendar or business days. And also, is there an acceleration clause to accommodate delays? We're going to talk twice about acceleration clauses because we find them very important, and you'll find out why. Next slide, please. So this is the language that you will see most likely. It'll say time is of the essence. And this is another way of saying that the schedule becomes a material term of the contract, or another way of putting that the schedule is so important and the parties to the contract expect to enforce it. This essentially allows the prime contractor to terminate the contract of a subcontractor if they do not adhere to the schedule. In a subcontract, the general contractor owner will specify a completion date and often include the time is of the essence provision. If the subcontractor does not complete its work on or before that date, the general contractor may choose to terminate the subcontract, hire another subcontractor to complete the job, and sue the original subcontractor for breach of contract. Additionally, questions to ask regarding the schedule, as there are frequent delays on the construction contracts, is there an acceleration clause in the contract? If the time delays are so great that there is an increase in labor rates and or material costs, does the contract mention business or calendar days? When it just says days, what are they, calendar or business? Because that'll make a difference in terms of time is of the essence. Next slide, please. Delays. So this ties into the time is of the essence. When you're delayed, on your contract? What are the procedures for submitting claims for delays? What is the timing for submitting the claims for delays? And what are the consequences for not submitting the claims in a timely manner? No damage for delay clauses are a risk allocator clause within the construction industry. Customarily, this provision provides that while the contractor or subcontractor is not entitled to a claim for delay damages, they might be entitled to an extension of time. Next slide, please. So what we've done here is we've shown in terms of the delays and this language from two different contracts is that in the first paragraph, you're given 2 days or 24 hours to respond to any delays. The second paragraph shows that if you do not respond to delays and there is a default, you'll be liable for all the losses. The first paragraph, this requirement means that the subcontractors have a certain amount of time to notify the prime owner of delays. And if they do not, it may mean that subcontractors have potentially waived the right to monetary compensation or time extension. In the second paragraph, since time is money, project delays can really cost the contractor, subs, and suppliers working on any given job. So what happens when the delays have a ripple effect and begin to cost serious money? Who pays for the delays? The contract language might tell a contractor, subcontractor how to mitigate liability for delays, which might mean notification and request for an extension of time. When a delay in the schedule is created, contractors must assess the specific circumstances surrounding the delay, the type of damage, the root cause of the delay, and react accordingly, and follow the contractual procedures for notification of the delay. If the delay rises to litigation to mitigate the damage for the delay clause, the contractor subcontractor must prove that the delay was so long and of such a nature that it cannot have been thought about by the parties before entering the contract. One example of that we've just experienced is projects were shut down by COVID. You also have to review if the delay was due to an owner's interference with the contractor subcontractor. The owner showed bad faith in delaying the project. The most important aspect to take out of this discussion is documentation and be able to provide documentation to record the delay so that you have it. Additional delays on the project may trigger increasing costs, and therefore knowing in advance if there is an acceleration clause in the contract is a good business practice, especially if the time delays are so great that there is an increase in labor rates and or material costs. Next slide, please.
Jennifer, a question did come in. It's regarding a 20-day preliminary notice. The question is, so what about the 20-day preliminary notice?
Right. The 20-day preliminary notice is an important right that you should preserve for yourself. And that has more to do with payments rather than delays that are caused on the construction, and that you should be following that process. And that's one of the reasons why I mentioned earlier following stop notice procedures, because those sometimes but aren't always talked about in the contract. Those are state of California law, and I always recommend to definitely follow those so that you preserve your rights to payment. And even if the contractor's not yet late, start the process. And ask if that answered the question, please.
Okay. Hope that answers your question. If not, feel free to ask us more questions.
Or you can contact us after the seminar and we'll be happy to go over it in more detail.
Yes, and we did get an answer. It sure did. So thank you.
Okay, next slide, please. Okay, there we go. This slide, you may see this very often. This usually doesn't harm contractors. It just talks about mutual waiver of consequential damages. This clause allows for waiving of consequential damages. Consequential damages, otherwise known as special damages, are damages that can be proven to have occurred because of the failure of one party to meet a contractual obligation, oftentimes leading to a breach, which means that one side feels the other has failed them in terms of contractual terms. Next slide, please. So here's the language. One example of consequential damages for an owner might include if there were loss of rents or income if a building were not have been able to open according to the agreed upon schedule. The importance of this clause is that a mutual waiver of consequential damages does not stop an owner or a contractor from applying liquidated damages to a contract if there is a substantial delay in the schedule. So even if the consequential or the special damages are delayed, liquidated damages still may be out there and you need to know what they are. Next slide, please. So liquidated damages, and for my speaking voice, I'm going to go with LD, are damages that are meant as a fair representation of losses in situations where actual damages are difficult to ascertain. It means they kind of guess how much the damage will cost, and they put that into the contract. In general, liquidated damages are designed to be fair rather than punitive, meaning they're not allowed to punish. And this goes back to that earlier that we talked about, reminder flowdown provisions, because if you're a subcontractor, liquidated damages from the prime contract between the owner will flow down into your contract. One definition of LDs are that they are meant as fair representation of losses in situations where actual damages are difficult to ascertain. And LDs change depending on the size and subjective importance of the project. LDs are designed before contract inception and represent actual damages, though difficult and impossible to prove. We've chosen two paragraphs. In this one here, you can see this is from the City and County of San Francisco contract, and it refers to section 007302, contract time and liquidated damages for each calendar day. They will also change depending on contracts. So the boilerplate language stays the same, referring to them, but what they are will change just depending on the size and complexity and necessity of the contract. Next slide, please. So here's one from a subcontract, and it says that you are liable for those liquidated damages in this one. The prime contractor may pass down via the flowdown or incorporation by reference provisions the LDs from the owner agreement to the subcontractor. On a project we were working on in San Francisco, we were assisting a subcontractor obtain a performance and payment bond of $600,000 to a prime contractor on a $65 million contract. The language in the subcontract was similar to the language that we're looking at on the screen right now. The City of San Francisco's LDs on the project started at $10,000 a day for substantial completion and accelerated to $50,000 a day for final completion on and were being passed down on a $600,000 contract. The way I looked at it was that on a $600,000 contract, if the contractor only had 10% profit, if there had been a delay, he would have lost the profit in 6 days. The subcontractor surety would not issue the bond as the prime was passing down the LDs directly to the subcontractor and felt the LDs were onerous or punitive. We worked with a project manager and a contract compliance officer on the project, and as a team, we were able to negotiate with the prime to have reasonable LDs passed down to the subcontractor that were acceptable to the surety company, and we were able to issue the bond. So this is where I'm going to reiterate once more. You do have at times, and if possible, some negotiation power, and utilize that for things that are the most important for you to change in the contract. Next slide, please. Okay, now we're talking about payment schedule, and this is where stop notices come back in. Thank you for bringing them up in advance. The payment schedule, one of the things you'll see in the contract documents it's really important to know is what is the timing for payments? What documents do you need to submit when you submit your progress payments? What is the retention? And what does the contract say regarding slow payment or non-payment? Next slide. So in this one, in the first one we see here, we see that it's a 5% retention and that the first progress payment is going to require the schedule of values and that they will base their progress upon that. Next slide, please. So this one shows even more the procedures. So when you're reviewing this type of language, this is what you want to really focus on. What to review: the progress payment cycle and what documents should accompany the progress payment invoice. Are there any forms required by the owner prime to be submitted? We suggest always requesting from the owner prime a sample of the pay application documents, if not included in the contract documents. What is the retention that an owner prime contractor has in the contract? Can you negotiate that amount? The one we saw above was 5%. But if it were 10%, could you get it down to 5% so you had more working capital? What is the timing of the payment? If the owner's payments are delayed, how long do you need to wait? Are your payments contingent on the prime being paid? What recourses do you have if the prime does not pay? We always recommend, besides following stop notice procedure, contacting also the contract compliance officers. We found them very helpful in assisting subcontractors and expediting progress payments. Also, one of the things that isn't in this part, but it should be around this area in the contract, is some prime contractors have a factoring type system in place to advance progress payments before the prime has been paid by a public entity, or they have a payment processing system in place such as Textura. It is beneficial to know the cost of either system. So if you submit your invoice and receive in advance, how much is that going to cost you? And what is the cost of Textura when you're submitting your progress payments? It's beneficial to know those so that you can include them in your bid in case you need to. Also, what recourses does a contractor or subcontractor have in the event of non-payment of progress payments? Once again, we always say follow the mechanics lien stop notice process, as well as contact your contract compliance officer. Next slide, please. Oh.
Jennifer, if you don't mind, I do, a question did come in. We want to know, what about small LBEs not coming in heavily funded? Usually that's the biggest hurdle, seldomly addressed. How would the payroll process work with his own workers?
The payroll, I apologize, let me see the question.
Sure.
Okay, so there's a couple things that are there because what I believe you're asking, you can correct me if I'm wrong, you're asking about getting your payroll paid on the project, which is a weekly requirement for you, whereas payment usually comes from the prime or the owner on a monthly process. So as an LBE, there are a couple recourses. You can negotiate with the prime, if it's a prime contractor, not the owner, to give you weekly payments to cover payroll. Or you can also come to us at the San Francisco Contractor Development Program, and we can work with you to qualify for the Contractor Accelerated Payment Program. That is one of the things that San Francisco and Merriwether and William have designed to assist smaller contractors in making sure that they have working capital funding for San Francisco qualifying projects. You'll get our contact information at the end. We'd love to hear from you. We can go into more detail. If this didn't answer your question, I'm more than willing to to call up John Miller to answer more questions. Next slide, please.
Thank you.
So after we've gone from payments, we're moving into change orders / claims. And we're asking similar questions, but with a slightly different. We're asking, what are the timing requirements? What can be included in the change order pricing? What are the allowable markups? What happens if you don't submit timely? So next slide, please. So here's one of the languages so that I've highlighted. Please note, without notice to sureties, you have 7 days, 7 calendar days to submit your claim. And it gives you a markup of less of 10%. And then it tells you that for general administrative expenses, overhead, supervision and profit, and any other direct or indirect costs, those are allowable. Next slide, I believe. No, I'm sorry, back, I apologize. So one of the things is you can see here, you have 7 days, at least on this, to time your change orders. Each subcontract, each contract will be different. What can be included in the change order pricing? It mentions in the bottom red, what are some of the allowable markups and inclusions. What happens if you don't submit in a timely manner? You may have waived your rights in order to submit a change order. One of the things about the notification to the surety company is surety companies will not like this, because changes to a contract or increases to a contract of 20% are considered a material change, and the surety won't feel comfortable that the prime contractors changing your contract to that extent without notifying them. So please note that most public entities, and you can find it, like I said, in searching for the boilerplate language online for the city and county of San Francisco or the county of Alameda, they have codified allowable markups in their contracts already. And so that you can know in advance what you can do. Please note that we also have a seminar on change orders that is already on our Merriwether and Williams YouTube channel. If you'd like more information on how to do change orders or why change orders are important. Next slide, please. So protection of work. This is a risk mitigation for the prime contractor and owner, allocating the liability of protection of subcontractors' work product to the subcontractor. Next slide, please. So this is what the clause kind of looks like. It'll say something different. The reason why I've included this is this clause protects the prime contractor and owner while a subcontractor is completing their portion on a project. So these clauses usually require a subcontractor to fix anything that goes wrong with that portion of work until the project is complete. Where these clauses can be problematic is if you have a multi-year project and your scope of work is only a section of the multi-year project. Then depending on the type of trade and risk of your work getting damaged when you are no longer on site, it could become costly and problematic to protect your work after you are no longer on site. So if you have negotiating power, I would suggest having the prime contractor agree to protect your work, for you to protect your work only while you are actively working on the project, and then allocate the risk to the prime contractor, have them sign off on your project when your section is complete, instead of requiring you to protect your project for the entirety of the contract until completion and having to wait for the owner, architect, and contractor. That should give you some more protection. Next slide. Indemnification. We hear this word a lot, and it's to indemnify another party is to compensate that party for losses that that party has incurred or will incur as related to a specific incident. It's also another way of saying to make them whole as if the loss had not occurred. Next slide. You will see a lot of indemnification language in contracts. It flows through it. But essentially, what you will see again and again in various paragraphs is that subcontractor or even contractor shall defend, indemnify, and save harmless contractor and owner. Indemnification, also known as hold harmless clause, is a duty to make good any loss, damage, or liability incurred by another. Indemnity has a general meaning of holding one harmless. That is to say that one party holds the other harmless for some loss or damage. As a subcontractor with a limited scope, you should review the indemnity language and attempt to limit whom you indemnify. If you are a subcontractor on a project and you do not have a design build scope, then it may not make sense to indemnify the architect, the engineer, or similar design professionals. If there are problems with the plans that get drawn, you do not want to be required to defend the plans. We also recommend that you have always with indemnity clauses and you have your insurance broker or your insurance agent review your indemnification and insurance language. Next slide, please. Insurance. I didn't want to subject you guys to the purpose, to the language of insurance. So this is the only slide you're going to get. The purpose of insurance is it's a risk mitigation tool. Its aim is to reduce financial uncertainty and make accidental loss manageable. It does this substituting payment of a small known fee and insurance premium to a professional insurer in exchange for the assumption of risk of a large loss and a promise to pay in the event of a loss. One of the things is not just that they pay in the event of a loss, but they also pay to defend you, which is really important. Once again, have your insurance agent review the insurance section to ensure that you are adequately covered, both the prime owner terms, if you are a subcontractor, and the subcontract insurance requirement. There may be additional insurance coverages that cover you and not the prime contractor and owner. Our motto is that it's better to be overinsured than underinsured. One example is a subcontractor was on a project and his insurance program met the requirements of the owner and prime contractor, but a review of the contractual insurance requirements did not include builder's risk. Builder's risk in this example would have protected the subcontractor's tools on the project site and materials before installation, as the prime contractor's insurance would not have covered the loss or reimbursed the subcontractor until the materials had been installed in the building. Next slide, please. Warranty. What is the warranty period? What is the relationship between a warranty period and performance and payment bonds? Warranty period versus manufacturer's warranty. Next slide. So in this sample, we have a period of 1 year from the date of final completion. Make sure to review the warranty period in your subcontracts as well as the owner's terms and conditions, because the warranty periods may vary. If performance and payment bonds are required, surety companies are uncomfortable with providing surety bonds for small and emerging contractors for projects with a warranty period of more than a year. If the surety company does provide a longer warranty period, say 2 years, this may increase the price of the bond, and you want to know that in advance. Also review to ensure that there are no errors in the contract specifications, requesting for a warranty period of the subcontractor instead of the manufacturer's warranty on the product supplied installed. As an example, we worked with a subcontractor on a project and the owner's specification asked for a 10-year warranty for a specific item. It was an error in the specifications, and we worked with the contractor through the contract compliance officers to correct the specifications before he entered into the contract. Next slide, please. Okay, here's the part nobody wants to do. These are disputes. How are disputes resolved? Who pays for disputes? Where are disputes litigated? What state law governs disputes? Next slide, please. So in this contract here, and each one is very different. This is arbitration. Rules for the, and they follow the rules for the construction industry, American Arbitration Association. So everyone wants to avoid disputes, and in the best possible world, there would not be disputes. But there are times that it is unavoidable, and knowing what the contract language says to protect your company is recommended. So you look in here to find out how disputes are resolved. Here it's through arbitration. Does the contract mention arbitration mediation? Is it who pays for the disputes? Who pays for the court costs, attorney fees? Does each party pay for their own fees? Where are disputes litigated? Will the dispute happen close to the project site, or is another location designated as to where they're going to have the dispute or mediation? As an example, we were working with a subcontractor on a County of Alameda project. The prime contract documents required that in the event of a dispute, binding arbitration would take place in Colorado. The project was in County of Alameda. The witnesses were in County of Alameda, and there would be substantial costs for a small and emerging contractor to move the litigation to Colorado. So we were able to negotiate, we were able to help the small and emerging contractor negotiate the arbitration would happen in California. And then you ask yourself, what law governs your contract? As a California contractor, you will most likely prefer California law to govern the contract. And next slide, please. So this is by no means the full list, but this is some ideas for you to get started when you look at your contract and before you look at your contract. So we say, does the contract include the correct price, scope of work? Are all exclusions that you listed in your bid proposal included in the contract? What is the project schedule and how does it affect your contract? And that goes to the delays. And time is of the essence, of course. What are the notification procedures and timing for delays? And what are the consequences of not adhering to the delay requirements? Have consequential damages been waived? What are the LDs or liquidated damages for the project? Next slide, please. What is the progress payment submittal process? What is the retention on the project? Are there cost factors associated with the payment process? What is the mechanics lien stop notice process? And I'm just letting you know, if you're going to do the stop notice process, you file it with the controller's office in San Francisco. What are the procedural requirements for change orders? What is an allowable inclusion in the change order? What should the surety company be notified of a change? When should the surety company be notified of a change order? Next slide. Protection of work compared to actual versus actual project duration. You shouldn't be forced to protect work when you are no longer on the job site. Who are you indemnifying? Who are you? Do you have sufficient insurance coverage? And once again, with both the indemnity agreement and the insurance language, we recommend that you have your insurance broker review that to get the most protection. What is the warranty period for the contract? Warranty versus manufacturer's warranty period. Make sure that those are correct in your contract. What is the dispute process? Where would the dispute process be handled? What law governs the dispute process? I hope this is giving you some kind of information and an inclination to review your contract documents. One of the nice things about working within the same region and with the same types of entities is that you can read their boilerplate language. So you're reading only then moving forward the things that change. I see a question.
So the question is, isn't it true you can't put a stop notice on public work?
No, you can't put a mechanics liens on public work. You can put a stop notice on public works, yes. So the distinction is a mechanics lien is when you put a lien on the property. You can't put a lien on a public works property, but a stop notice is perfectly allowable. And we always recommend that you file the preliminary notice because that is protecting yourself and preserving your rights to file the stop notice if needed.
Thank you.
Okay. Next slide, please, if no other questions. Thank you for attending. We really appreciate it. And here is our contact information. We also are including the YouTube playlist. I would recommend for anyone who hasn't seen it, going back and seeing the change order webinar. Thank you very much, and I appreciate your coming.
Since we don't have any further questions, I think we're going to wrap up the webinar, and thank you everyone for attending.